Good evening. Mr. Manoj Kumar Anand, who is the resource person for today, has already done sessions with us, and he's the president of the All India Insolvency Professional Association, in short, AIIPA. Therefore, when we found that we were running on the same page to the effect that there should be decimation of the knowledge, information being shared, and people are sensitized in the true perspective. And that is what we all say, that where there should be knowledge, where everyone can understand the nitty-gritties of all aspects in the right manner and the right way. Voluntary liquidation of the corporate's unhidden treasure and procedure is one of the aspects which we read a lot, but the manner to understand the things is always a facet which one intends to learn. And there cannot be a better resource person than Mr. Manoj Kumar Anand, who is a chartered accountant and an IP professional. Manoj Kumar Anand has created his niche within the market, not only as the chartered accountant, as well as the insolvency professional. He has handled various assignments as an IRP, RP, PG, liquidator, and process advisors. He has done not only small, but big processes in this regard. But as they say that rather than reading a biodata of a person, once you hear a person who himself hammers everything which is an ounce of gold, it would always be a pleasure, that too on a weekend, to hold him rather than on the process of introducing him, but to straight away ask him that keep on sharing the knowledge and it will be enlightening the society at large. Over to you, Manoj. It's always a pleasure connecting with you.
Thank you, Vikasji. Thank you very much for giving me an opportunity to interact with my people, my advocates, my chartered accountants, my insolvency professionals, and thanks to the audience also, because when you gave me this opportunity to present myself before you, I studied this topic again, as a result of which I polished my knowledge. I feel these webinars, as far as a speaker is concerned, this is best for us because it makes us to learn. Otherwise, in our normal routine, we are always involved in doing all the little and small things there. In our daily G20 is going on. Somebody asked that the government is putting up so much energy in G20, what they will ultimately gain out of that. तो मेरे को उनसे एक हिंट मिला. मैंने भी सोचा कि हम लोग वेबिनार्स करते हैं, अटेंड करते हैं, प्रेजेंट करते हैं, तो इनसे क्या हमारे को गेन होता है. तो somebody from the ministry, very senior person, replied that this kind of G27, what the India is holding out, it will open us a lot of paths for us. Maybe, if we look at China, they are only opposing. Otherwise, every other country is saying that India should have a UN permanent seat. Maybe with the hospitality and kind of strength seeing in the G20 seminar, such type of things and such type of paths will open up. Similarly, in every webinar, I polish my knowledge. People like you who are my esteemed audience, they listen, and maybe with a particular webinar you may not be able to have assignments directly, but it will definitely make you to generate for you. If something the unhidden is there, that can always make you to extract out of that hiddenness and increase your professional practice and otherwise also. तो आज का जो मेरा जो वेबिनार है, मेरी प्रेजेंटेशन है, मैंने बनाई भी इसी पर्पज से है कि because we people are elite class of the society, and elite class in business is termed as corporates. So we always one or the other way are dealing with the corporates, but in every corporate, as far as in my CA practice, what I've seen is that in every corporate, especially with the big groups, there is always a hidden treasure. Hidden treasure means that block up capital. What happened is that you started a company because of one reason or the other reason. You invested in the form of capital. There may be 50 lakh rupees, 50 crore rupees, maybe more than that. And then you realize that this capital has stuck up. And now companies like 2013, Section 185, 187, 190 provisions are so stringent that diversion of funds is also, very difficult. At the same time, if you try to withdraw the money, you have in market that there are 2 or 3 perceptions are there that if we go for the liquidation, it will take years. And it was the fact also. And if we divert the fund, then our auditor will get hold of us. But in my today's webinar, you will be easily able to understand and look into the aspect that you can withdraw your capital, and that too with a very, very minimum cost, and that too within a timeline of maximum of 90 days. And if we plan it, the planning which I should be sharing with you, if you plan it properly, perhaps you can withdraw your capital maybe within 60 days or something like that. With this objective, that how we can broaden our knowledge as far as voluntary liquidation is concerned, I'm starting my screen share with you. Sharadji, please allow me to screen share. Vikasji, I request you to allow me my screen share, please.
Sharing?
Screen share.
Just hold on. Now just check it out.
Yeah. I'm able to share now, please.
My difficulty is I hear it with the mobile because the audibility is much better. So, and in a mobile and a Zoom meeting, there's some difference of the timing.
No problem.
Yeah.
No problem. I hope my screen is absolutely visible to everybody now.
Yes.
This is a small introduction of mine and my contact details also, because many of times after seminar, people ask me how to contact you. So I've given it there. Oh, okay. My office put it there. I was at Singapore representing India in one of the conference whereby on IBC I delivered a lecture on and that particular sheet they haven't closed there. Hidden treasure. Yeah. Okay. My objective of this particular webinar is to enlighten my audience that how we can get benefit under voluntary liquidation, and what is the hidden through which we treasure which we can extract and then get benefit out of that. अगर हम वॉलंटरी लिक्विडेशन में जाते हैं, अगर हम इसको इस तरह से प्लान करते हैं, whereby we, let's take it with an example instead of going exactly with the sections. For example, you purchased in a company, you purchased a particular property. It happens. It's a normal business practice, especially in the big houses, that they buy property in one company and they do operations in another company, and the company in which operation is going on, they do give that property on rent there. Just presume a situation that you purchase a property which has increased its price manyfold. Maybe 20-30 years ago, you purchased it at a cost of 1 crore rupees, and now it is costing you 30-40 crore rupees. If you sell that property and put that money in the company, in that case, Section 45, Section 47 of the Income Tax Act, you have to pay the capital gain tax. But voluntary liquidation provides you an opportunity whereby you can transfer this property to the shareholders without paying any taxes. Naturally, they have to pay the taxes when they will sell the property. Because the reason for that is that under Section 46(1) of the Income Tax Act, if any property is transferred to the shareholders at the time of liquidation, then it is not taxable. If you remember, we have a Section 56, subsection 2, subsection 10 in the Income Tax Act, which clearly says that all transactions should be at the market rate. This particular section overrides that particular section. In simple terms, if you have a property company and you want that it is becoming you want to transfer it to the owners or the shareholders, voluntary liquidation can provide you a route whereby you're not supposed to pay any taxes. This is one treasure. Second treasure is, You can, otherwise also, you can return capital by paying dividend tax only for excess transfer as per section the 194J. That is at the rate of 10% only. It is not 105, it is at 10% only. Some topographical error. What I mean to say is that for example, say you have a capital of 1 crore rupees and there are 10 crore rupees of reserve and surpluses. You have to deduct against that 10 crore rupees TDS of 10% only. That will come out to be 1 crore rupees, which will be taxable in your individual returns also. On that basis, you can return 11 crore rupees to shareholders. Yes. Another privilege has been given is that earlier this winding up reasons were gone by Companies Act 56, Section 560 earlier than Companies Act 2013. Now it has been transferred to the NCLT or brought under Insolvency and Bankruptcy Code. IBBI, who is governing IBC, looked deep into it and realized that obtaining NOC, which is a procedural part of voluntary liquidation, is something difficult. They issued a circular which is applicable and binding on the income tax authorities also. Because of the overriding IBC prison, you are not required to obtain any NOC from the income tax. What happened that I remember that in my days of practice, when Companies Act 1956 was applicable before 2013, Section 560 was there, whereby we, if we come across that, whereby we want to get rid of a particular company, what we used to do that on the one side we have a capital, on the another side we have a profit and loss account in debit, and match it. No liability, no asset, and then we put up an application before the ROC, and the company was being struck off. But this provision substantially changed when 2013 Act came out to be there, and practically under that particular Act, such type of strike-off was impossible. And the only way out now with us is voluntary liquidation. Timeline is only 90 days. IBC has prescribed timeline for, in case of voluntary liquidation, 90 days. And there is a timeline of 180 days also. But if we plan our affairs, we can end up our voluntary liquidation within 90 days. That, at present, I'm telling you only broader hidden traces in voluntary liquidation. Later on, I tell you when we should come to the procedural part, that how we can use this timeline. Yes, as I told you, voluntary winding up cases under section under earlier regime of 1956 were taking 20 years, 30 years, 10 years, because you people know better than me that honorable high courts are very busy, and if there is any asset, they have a very lengthy procedure of selling it out there and then transfer into the proceeds and all these things. One of my friends was doing this particular case, and he told me that when he was selling, it was some big national level drug company who are having stores all over India, and all of a sudden they thought of going for a voluntary liquidation under old regime 195.56. At that time, judge got doubt that stock may not be sold at particular at market price by the liquidator. He said that the honorable judge started supervising each sale of the stock in each city, and that consumed a lot of years in relinquishing the whole stock. Yes, R is a vibrant and modern economy. If we have a right to form a company, which our ministry claims that within 3 days you can form a company, or practically you can also form a company within week 10 days. If we are a vibrant company, if we are now tax savvy, the Ministry of Corporate Affairs is working tax savvy, all forms are being filed online, everything there. Why don't we have a right to exit also? And that right to exit so fast, why not? In USA, you and other developed economies, you have a very fast right to exit also. That situation is now has come to the India also through IBC, under voluntarily liquidation. In fact, right to exit, I've just shared with you that I found a very interesting news as far as right to exist is concerned, that in UK, the second largest city is Birmingham. In Birmingham, that municipality has gone for the insolvency. I don't know the details, but I was really shocked and surprised to see that how advanced those economies are there, and that even municipalities or some government authorities can also go for liquidation. In nutshell, their liquidation laws provide that they have to maintain only minimum services. Nothing more than that will come to them, like no luxury, nothing like that with their reason of their liquidation was that they holded some sports seminar or something like that, which has eaten up their all their sources and money. Yeah, this voluntary liquidation is mandatory if it is provided in the article of accession or memorandum of accession. What happened is that, practically I tell you how it is being provided. For example, in Delhi, it happened that when in Delhi, when metro construction was going on, 3 or 4 big companies formed a JV. And in that JV, that was in the form of a private limited company, whereby they put it in the article that the moment this metro work will be over, this company will be dissolved or this company will be liquidated. So if that situation is there, you have to go for mandatory winding up. And the only the situation is now voluntarily winding up. Yeah, this is, I already shared that other benefit is that you can save administrative costs on maintaining a company. Yes, my 8th point is that even as an advocate or as a chartered accountant or as an insolvency professional, you want to learn that how we can go for the voluntary liquidation. The procedures are very, very simple. You'll be shocked to hear that for whole voluntary winding up under IBC 2016, there is only one section which deals with it. That is section 59. And there is a one set of regulation which have around 41 regulations. If you read and study that particular section, in fact, आज मेरे आज के webinar के बाद तो आपको वो भी पढ़ने की जरूरत नहीं पड़ेगी, because I've included there that particular session therein, that you can easily be able to impress any of your client to go for the voluntary liquidation. But even in theory also, सिर्फ एक section है 59 और उसके साथ एक regulations है इस चीज को समझने के लिए कि voluntary liquidation क्या है. Yes, when we did the practice of insolvency, and we came across some very interesting cases also. If there is some sort of liability which has not crystallized. For example, you're going for a liquidation and there are certain tax appeals are pending, maybe income tax or maybe GST, that can't act as a hurdle for you to close the company. If any of the stakeholders can take the responsibility of paying them, courts are allowing you this voluntary liquidation. Another part, the best part which I feel I saw in these voluntary liquidation, in fact, in my IBC practice, that you are the owner of the company till companies under IBC. As far as payment of fees and other things is concerned, you are not supposed to ask to your client. You can take it as you want, because bank account of the particular CD is operated by you. Again, I demand to the court. I demand to the authorities that many times I've seen that our webinars also message this to the government also, that if you're, as you are providing us right to registration, maybe GST, obtaining PAN, obtaining TAN, or forming a company, all this thing at a very fast pace, please expedite the right to exit also. Okay, now let's go for, I've already told you that why we should go for liquidation, voluntary liquidation. What are the benefits we have for it? I've already earmarked points as far as with my experience only, whereby we have planned for our clients of this sort of voluntary liquidation. Now let's move to what, how we can go for the voluntarily liquidation. I think by this time this misconception will be over, because still when we talk in our fraternity, who are not much aware of this sort of practice of the doing the liquidation or IBC and something like that, they still feel that company तो एक चक्रव्यूह है, जैसे वो महाभारत में चक्रव्यूह था ना कि उसके अंदर आप घुस जाओ बाहर नहीं निकल सकते, मीनिंग देयर बाय कि once you invest the capital in the company, it is next impossible to withdraw it. ये चक्रव्यूह नहीं है, आप इससे बाहर भी निकल सकते हैं, और कैसे निकल सकते हैं ये मैं आने वाली स्लाइड्स में आपको बताऊंगा। वो मैंने ऑलरेडी आपसे बात कर ली कि सेक्शन व्हाट पीपल, जब उनको लगता है कि उनको आइडिया नहीं मिलता कि इस चक्रों से बाहर निकलने का, तो वो जो कैपिटल इन्वेस्टेड होती है वो अपनी एसोसिएट कंपनीज में जहाँ बाकी जगह पे उसको डिवर्ट करते हैं, लेकिन वो उस डिवर्जन्स के ऊपर मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स का या कंपनीज एक्ट का बहुत जबरदस्त कंट्रोल है। यू हैव टू स्ट्रिक्टली कंप्लाई विद सेक्शन 179, 180, 185, 186 and similar more sections. For example, that under section 185, you can't, divert funds of more than 60% of your capital and reserves. That section is put on you. You can't give money to the directors or their associate companies. A lot of things are there. Then they go for planning, which in fact is not a planning but misplanning. If you get the eye of the auditor or ministry after your filing. No law gives you an option to return back your capital through voluntary liquidation. Okay, before we move further, let me explain you very, very briefly what were the earlier provisions. These provisions are not applicable unless some pending cases are going on. Very briefly, I tell you, earlier provision, the companies are as you people are aware that companies are gone by Companies Act 1956. So when 1956 was prevailing, at that time, similar provisions were section 560 was there, which we call strike off provision. As you people be remembering, or I tell you that in case of strike off, you have to compulsorily create losses equivalent to your capital. But that was compulsory creation. There was no way of returning back the capital. This planning was possible only for small companies. For big companies, it was never possible. Law gives you an opportunity to return back your capital. Okay, as far as Companies Act 2013 is concerned, which is applicable at present now, it deals with chapter 18, section 248 to 52, which deals with the removal of the names of the companies from the registrar of companies. Chapter 20, part 1, section 272-303 deals with the tribunal bind funding. Chapter 20, part 2, section 304 to 323 deals with the voluntary binding. अच्छा, अब इसके अंदर जो मैंने पहला वाला कहा, chapter 18 जो है, it is parallel to section 560 earlier, which was their strike off, but only big difference is that in this case now ROC has also power, whereby if you're not doing business for the 2 years, whereby if you are not you are not have not filed your annual return, then they struck off the name from the company from the register. MCA himself struck off the name from the company from the register. If you remember, 3-4 years ago, our Honorable Prime Minister Modi ji very prolifically told to the Parliament that हमने इतनी सारी कंपनीज को स्ट्राइक ऑफ कर दिया, और जो एक क्या कहते हैं, जो एक शायद एंटी ऑपरेशन का काम कर रही थी या कुछ और कर रही थी, हमने उनके ऊपर एक नकेल कस दी. So that was under these provisions, chapter 18, the Ministry of Corporate Affairs struck off the companies. और इसका सबसे बड़ा नुकसान ये होता था कि उनके जो डायरेक्टर्स थे वो बाकी कंपनीज के अंदर भी डिसेबल हो जाते थे. So if I remember, Kotak Mahindra was one of the very known personality at that time. When one of the small company got stuck up because of these reasons, and he become ineligible to be the director in all his listed companies or something like that. But when he filed application showing his this showing his this the thing there, the tribunal granted him a relief. Yes. The provisions of voluntarily winding up under chapter 20 have been removed from the Companies Act 2013 and now governed by the Insolvency and Bankruptcy Code 2016. Now, what I mean to say is that, yes, before that, I tell you that in part one, tribunal winding up. Tribunal has also a right to wind up, but that situation is practically used very, very, very rarely. You know, what that situation is, somebody is doing illegal business. Somebody, some enemy has created a company. For example, if you remember that during last approximately 6 or 7 months ago, there was a very big hue and cry that some Chinese companies are doing illegal business in India, or they have diverted a lot of funds from India to China. In that case, tribunal can wind up those companies. They have the power under Chapter 20, Part 1 to do all this thing. No. Now I have given you the basic background. Now already 23 minutes have passed. Now let's move to our core topic of voluntarily winding up, how we can go for it, what are the procedures and other things there. But this time, if you have any question, you can ask me related to my topic, or I can move forward. Okay. I move forward since there is no question. Now, you'll be surprised at why this provision from Companies Act 2 has been removed from the Ministry of Corporate Affairs to IBC. Reason for that is two. One is that, with the passage of time, Ministry realized that the liquidator, which is being appointed as under Companies Act, perhaps their proposition on market, they realized that they're paying a lot with the company. जो भी उनके एसेट्स वगैरह होते थे उनको एक पर्सनल लेवल गेन के लिए या अदरवाइज के लिए वो सेल वेल कर रहे थे. एज अ रिजल्ट ऑफ credibility of those liquidators downed a lot, and Ministry of Corporate thought of removing removing that power with them to the insolvency professionals, because insolvency professionals are better placed. They are controlled by the IBC also, agency also, and they have a different type of class, and that is why government thought of removing these winding up provision, voluntarily winding up provisions from this Companies Act to IBC. And it is akin to also, because under IBC, if company is not able to get resolved, then it goes under Section 33 compulsory to the liquidation. In that case also, in that liquidation or this voluntarily winding up, voluntary liquidation or compulsory liquidation are also very much correlated. And in fact, a lot of reasons of voluntary liquidation is akin to normal liquidation also. Okay, I've given you, consumed your 20-25 minutes. Now you'll be interesting to know that what do it has any market effect or not? Or these businesses are theoretical only. That latest statistics which I've got, that will really make you to feel happy that people and business community are using quite extensively these results. At the end of June 23, 2013, 1,607 cases have been filed. I just tell you that so far out of them, 17 has been withdrawn. Out of the total, final reports have been submitted in the case of 1104 cases, and 486 cases are going on. I just tell you that our IBC started only in 2006. Hardly 7 days, 7 years are passed, and this much is the other data that because of these reasons, capital of 11,775 crore has been withdrawn through this thing. Assets of the value of 12,086 has been used for this thing, and this is all statistical data which can help you to understand that after IBC 2016, these pieces are being used very extensively. This date is 23, not 13. As I told you earlier, there is only one section which deals with the voluntary liquidation. That section is 59. Ministry of Corporate Affairs wide notification dated 30th of March 2017, made applicable this particular section. But it includes in one of their subsections, section 59, it has been written that section 35 to 53 of chapter 3 and section 68 to 77A of chapter 7 shall also be applicable on these voluntary liquidation, meaning thereby that substantively we need to study section 59, but to effectively implement that section 59, we need to understand basic reasons of section 35 to 53 also, which is part of the chapter 3. But section 60 and 277A simply consist of penalty provisions, which is applicable to all insolvency cases. And we need to understand voluntary liquidation process also, which was notified immediately by the IBBI after one day as on 31st March 2023. And both these provisions are made applicable from 1st April 2017. It has 1 to 41 regulations. I have reproduced whole section 59 in my slides. I'm just slowly and steadily through my animation reading each and every section, but I have summarized it also later on, the vital provision of this particular section. But I made this section 59 as part of my presentation only with the intention, because this is a single section and need to be understood very, very diligently. I'm quickly passing through without reading it, because crux and summary of this section I have summarized in my feature one slide. Yes. No, let's understand, the crux of the section 59. Section 59, through its subsection, provides that what are the preconditions for going for voluntary liquidation. By this time, you must have understood it is applicable only to the corporate person, which includes LLP also, but excludes financial service provider under central government uses power under section 227, meaning thereby that if any of the companies, say for example a company which is governed by RBI, or with a company which is governed by insurance authority IRDA, if there is some special those type of companies, they can't go for the voluntary liquidation until for those companies to go into the voluntary liquidation, the power has been given to the central government. They have to specify that this company is going for liquidation, which is with the permission and with the consent of concerned regulator only. And popularly we have financial companies governed by RBI, meaning thereby that if any NBFC has to go, it can't go. It requires the approval of the RBI, and they appoint administrator, and their prisons are separately gone there under the overall umbrella of IBC. Now, second precondition for voluntary liquidation is that that particular company has not committed default in section default that company has not committed any default. Default has been defined under section 3 subsection 12 of the IBC. It means non-payment when due, meaning thereby that there should not be any creditor in the company balance sheet, or there should not be any creditor. If there is any creditor, then you can't go for the voluntary liquidation. You require regulation Firstly, from the majority of directors mean more than 51% should agree for that. The company has no debt, as I told you, or if there is any debt which comes out to be there, which is not shown in the balance sheet, or when you issue the public notice and then you come across for that particular debt, then that company must be able to pay that debt. That particular there is no, it is not defined, it is a defraud. Spelling mistake committed by my office. I should change it later on. It is the intention of voluntary liquidation is not to defraud. You have to make a, the directors have to make a declaration of solvency within 4 weeks of passing of the members' resolution. Members' resolution has to be a special resolution, meaning thereby that 2/3 of the members should consent for this thing. Yeah, but it can be an ordinary if it is prescribed under article of association, memorandum of association, that on the happening of this particular event or after a particular period, this company will be liquidated. If it is a creditors, I'll let you know that it is possible, as I earlier written, that there should not be any debt. But if any debt comes out to be there, even then you go for a voluntary liquidation, subject to consent by the 2/3 creditors. Date is very important, because from the date under section 59 subsection 5, all subsequent proceedings will start. तो जो voluntary liquidation की date है वो तब है जब members का resolution pass किया जाता है. And if there is any creditors, then it has to be proved by the creditors. Otherwise, this date won't be relevant. You have to go for declaration of solvency. A declaration from majority of the debtors of the company verified by an affidavit stating that they have made a full inquiry into the affairs of the company, and they have formed an opinion that either the company either the company has no debt, or that it will be able to pay its debt in full from the proceeds of the assets to be sold in the voluntary liquidation, and the company is not being liquidated to defraud any persons. मोटे मोटे तौर पे जो प्रैक्टिकली लोग करते हैं, मैं आपको समझा देता हूँ. अगर किसी कंपनी को टैक्स लायबिलिटी आ गई, उस टैक्स लायबिलिटी का अपील में जीत गए, डिपार्टमेंट ऑफ पेमेंट्स अपील में चला गया, मे बी ऑफ डायरेक्ट और इनडायरेक्ट टैक्सेस लाइक सर्विस एक्ट, जीएसटी, एक्साइज, कस्टम और समथिंग लाइक दैट, तो आप उस केस के अंदर आप कंपनी को वॉलंटरी लिक्विडेट नहीं कर सकते until unless you make an arrangement of payment of expected taxes against that thing there. तो वो that defraud is not allowed in this case. Members' approval. A special resolution of the members of the company in the general meeting requires the company to be liquidated voluntarily, and appointing an insolvency professional to act as a liquidator must be passed within 4 weeks of the declaration of solvency. Nothing to explain. Creditors' approval. If the company owes any debt to any person, creditors representing 2/3 of the value of the debt of the company shall approve the resolution passed for voluntary liquidation within 7 days of such a resolution. Yes, here what we learned from our experience that I'm including in my slide as a special comment. Basically, if you feel that you have any creditors or you have any crystallized creditors, you pay to them before going for the voluntary liquidation. We always try to plan our affairs in such a way that whereby we pay to the creditors so that there is no creditor, and that if you don't have any creditors, that process will really help you in going for the voluntary liquidation quite easily. Another condition is that the above declaration should be accompanied with the audited financial statement and record of the business operation of the company for the previous 2 years or for the period since its incorporation, whichever is later. A report of the valuation of the assets of the company, if any, prepared by the registered value. If you have any assets, you need to prepare a report for that. And here again, with our experience, we have learned that ultimately liquidator has to sell these assets. It's better that when the company is alive, you sell all the assets until unless you want to transfer those assets directly to the shareholder. For example, if you have a car, if you have any the debtor, recover the money from him. If you have any stock, instead of liquidator selling all this thing, make a balance sheet whereby you have capital and bank balance only. Try to make it. In that case, everything goes very easy. Another important point is that the company shall notify the ROC and the IBPA about the resolution passed to liquidate the company within 7 days of such a resolution, or the subsequent approval by the creditors, as the case may be, as per section 59, subsection 4. Yeah. No. Here one very big catch is there. Until unless you inform to the IBPI or ROC that about you're going for the voluntary liquidation process there. After that, I tell you the process for that doing this thing, because we faced a very big hurdle while intimating this thing practically. What at present situation is that MC has delegated all work to IBPI, and change the master data is done at the behest of the IBPI only, and typically requires stringent follow-up with the IBPI. Meaning thereby that you need to file papers theoretically with the ROC also and IBPI also. In IBPI, it has only one branch all over India, that is in Delhi. We were lucky enough, मीर भवन में इनकी ब्रांच है, वहां पे आपको इसको मीर भवन कनॉट प्लेस के अंदर इनकी ब्रांच है, वहां पे एक पर्टिकुलर सेल बना रखा उन्होंने जो कि ये वॉलंटरी लिक्विडेशन से डील करता है, और वहां पे आपको जाके लिस्टिंग करनी पड़ती है। जब तक आपके कंपनी के मास्टर डाटा के अंदर वो लिखा हुआ नहीं आता वॉलंटरी लिक्विडेशन, तब तक आप आगे मैं आपको बताऊंगा कि यू नीड टू ओपन ए बैंक अकाउंट, यू आर नॉट एबल टू ओपन ए बैंक अकाउंट, यू आर नॉट एबल टू प्रोसीड फॉर anything further, because if you sell something and you want to put the money after start of the voluntary liquidation, you have to put money only in that account, whereas a company in liquidation is returned. You can't put that money in your normal account, and be mentally prepared that it takes approximately earlier when we informed to the ROC changes the master data say within a week, 10 days, but now because of the involvement of the IBPI, this process takes approximately 1 month practically in change of the master data with the wording in liquidation. Valuation. The valuation you need to done, and the best part here is that the responsibility of doing valuation is with the director, which is quite different under other IBC provisions, whereas the valuation responsibility was with the liquidator or with the RP. As I told you, we generally try to sell all the assets beforehand, so that we don't find any, we don't need to require valuation and have at the mercy of the liquidator to distribute the proceeds to sell from the assets. As received from the asset. Public announcement. Public announcement is a something very big in this thing, because only through the liquidator shall make a public announcement within 5 working days of his appointment to submit claims within 30 days. It must be published in one English daily and one regional newspaper wherein the registered office of the corporate person is situated. It must also be posted in the website of the corporate person if having. It must be sent to the IBPI via email at this particular address for posting it on board's website, because this is the public announcement which is very important. Why it is so important? Because this is the only thing which opens up a gateway for public to know that company is going for the voluntary liquidation, and if in the accounts anything hanky-panky has been done, they should come forward. I have prepared this these points that what public announcement should contain. These are the normal things. I just share with you one of the format of a public announcement which we made earlier. Yeah, this is the format of the public announcement which we did, I think, 6 months ago. This is only for your reference. You need to put advertisement in the newspaper also. We have shown you the cutting of the newspaper also, one in Hindi and English, because R was Delhi and a Delhi-based company, and we put it in the business standard. Yeah, this is there. This is nothing new. It's something quite normal. I come back to my screen again now. Importance of public announcement, I can share it to you with one of the case law, which I extracted from the IBBI. IBBI order number so IBBI so and so dated 16/4/2020 by DCF IBBI against Mr. Tarun Jaggi. He made public, he did not make public announcement within 3 days, but he made public announcement after 18 months. IBBI imposed a penalty of 1 lakh rupees on the liquidator for delay in the public announcement. The purpose of telling you this case is that what big importance has been given for the public announcement by the MCA. Yes. Another practical aspect is to opening a bank account where it should be written that companies under liquidation, like that. Opening a bank account is a Herculean task. It is not easy that banks are opening the liquidation account very easily. We face a lot of difficulties while opening a bank account. But with why I'm telling you this thing, that with our experience, you can open your bank account now within 2 or 3 days. How you can open that particular bank account within 2 or 3 days, which with us took more than 1.5 months. Reason for that is that I just tell you, and if you go for any voluntary liquidation opening of account, go for it. Every bank has its own set of guidelines. Some people, for example, our existing court was in the HDFC. They were saying that unless ROC changes the record, we won't open your bank account. We are falling out with the IBBI, and they were taking their own time in change of the master data, and hence they did not open. But on the other hand, somebody referred us that you go to the Kotak Mahindra Bank and Yes Bank. They, with the kind of resolution, the members resolution, directors resolution, and with the KYCs of the other person, which I think I have noted. Yeah, with these documents which are easily available, certificate of incorporation, MOI, AOI, PAN of all directors, this income tax profile screenshot. Why I'm sharing you all this thing is that you keep record of all these things. In case of your any of the cases, you just simply collect all these documents beforehand and go to the Yes Bank and or Kotak Mahindra Bank. They will open up your account easily. These are the documents are easily available. But if you try to open a bank account with a public sector bank or HDFC, at least I face a lot of difficulty in opening that particular account. It's a subjective matter. But in our fraternity, everybody says that they face a lot of difficulty in opening bank account. Okay. Another is claims. You'll ask me if you are listening me very carefully that when I said that there should not be any title, then how claim should come out to be there. There may not be any creditors, but in case of public announcement, people may come out with some sort of claims. Claims. What is a claim? Let's understand legally what is a claim. Claim means a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. A right to remedy for breach of contract under any law for the time being in force, if such breach gives rise to right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. That is all. तो ये क्लेम बेसिकली क्लेम ये है कि अगर कंपनी ने किसी के पैसे देने हो और वो अपना पब्लिक अनाउंसमेंट के अगेंस्ट क्लेम फाइल कर दे, तो इसके लिए अलग अलग फॉर्म्स हैं, कौन कौन से किस को क्लेम फाइल करना है. डेट व्हेन यू शुड कम टू द दिस थिंग देयर, आई लेट यू नो. These are all things which in the process of voluntary liquidation you need to understand. इसके अंदर हमारे इनकम टैक्स बिजनेस है वो उसको पढ़ना भी बहुत जरूरी है. Why it is so important that there are only two sections which deals with this voluntary winding up. One is section 176. It deals with not only with the voluntary winding up, it deals with all the discontinued business. I just share the whole section with you. It is very important. इसके अंदर बस एक ही 176 सबसेक्शन 3 के अंदर आपकी ड्यूटी होती है कि विद इन 15 डेज आपको कंसर्न्ड असेसिंग ऑफिसर को नोटिस देना होता है, लिक्विडेटर को, कि हमारी इसकी वॉलंटरी लिक्विडेशन स्टार्ट हो गई है. सेकंड इसका यानी कि इसके 2-3 पॉइंट्स हैं. मैं पहले 176 आपको पूरा बता देता हूँ. For example, if let's understand the subsection 4 with an example that say that some court case was going on and you received the favorable judgment. In that case, favorable judgment comes to be there and company is under voluntary winding up. It has been dissolved. In that case, if money comes out to be there to some of the shareholder directors as mentioned in the order, then that particular person will be accountable for that particular money. He has to pay tax against that money instead of the company for that particular purpose. This is subsection 176, subsection 4 says. Another important section is section 178. यानी कि विद इन 30 डेज हमारे को इस सेक्शन के अंदर आपको नोटिस देना पड़ता है कंसर्न्ड असेसिंग ऑफिसर को. The assessing officer shall, after making such inquiries or calling for such information as may be deemed fit, notify to the liquidator within 3 months from the date of which he receives notice of the appointment of the liquidator the amount which, in the opinion of the assessing officer, would be sufficient to provide for any tax. Meaning thereby that the EO को जो है within 3 months बताना पड़ता है उसको लिक्विडेटर को कि भैया इतना टैक्स ड्यू है, ये आप पे करके दे दो. सेकेंडली सबसेक्शन 3 के अंदर ये एक रिस्ट्रिक्शन लगाई गई है लिक्विडेटर के ऊपर कि अगर वो कोई भी एसेट जो है वो जो कंपनी अंडर लिक्विडेशन है उसको सेल नहीं कर सकता विदाउट दी कंसेंट ऑफ प्रिंसिपल चीफ कमिश्नर और चीफ कमिश्नर. अगर वो कोई एसेट सेल कर देता है और उसकी लाइबिलिटी है जो इनकम टैक्स की लाइबिलिटी है इधर इन द पोर्टल और थ्रू द एओ, in that case he will be responsible for payment to the authorities, income tax authorities, to the amount of default along with interest. वो पर्सनली लायबल होगा सरकार को टैक्स पे करने के लिए अगर कुछ उस कंपनी के केस ड्यूज हैं और वो कंपनी के लिक्विडेट करके उसके एसेट्स को स्टेक होल्डर्स में डिस्ट्रीब्यूट कर देते हैं. तो इस करके ये जो सेक्शन 176, 178 इसकी कंप्लायंस बहुत ज्यादा जरूरी है प्रॉपर वे से. मीनिंग देयर बाय कि अगर कोई टैक्स का ड्यूज आता है तो लिक्विडेटर मस्ट बी कॉशियस कि वो टैक्स ड्यूज पे करते हैं बिफोर डिस्ट्रीब्यूशन ऑफ प्रोसीड्स ऑफ द लिक्विडेशन. Yes. इसके अंदर पहले earlier it was a provision that before dissolving the company, when you put the liquidation application, you were required to obtain NOC from the income tax office, and getting NOC from the income tax office was a Herculean task. You put an application there, they will see their portal, they will see their record, and takes months to give you NOC. And many a time on some small accounts they don't give you the NOC. For example, they will say कि हमारे पास पुराना रिकॉर्ड है नहीं है अवेलेबल, जब तक वो हमारे को मिलेगा नहीं था, जिस पर्टिकुलर वार्ड में वो रिकॉर्ड पड़ा होता वहां से आप रिकॉर्ड मंगाओ करो एंड देन वी शैल लुक इनटू इट. नो कंप्यूटराइजेशन हैज बीन डन बट स्टिल अपील्स वगैरह का जब अपील्स या वैसे कंप्यूटराइज हो गया बट मे बी सम other manual record is there, and until unless you liaise with a concerned ward and this thing, you don't get NOC from them. And in every hearing before NCLT, they will say that हम record ले रहे हैं, कर रहे हैं, वो कर रहे हैं. Since this was the provision in the Taxation Act, judges भी आपको liquidation allow नहीं करते थे जब तक आप को NOC नहीं मिलता था. Seeing all these difficulties, we represented this thing to the IBBI, and IBBI came out with a circular, circular number so and so, whereby they said that in case of voluntary liquidation, I'm not talking about other liquidation, that normal liquidation, you still need to have this thing, but in case of voluntary liquidation, you're not required to update any NOC. This is the IBBI circular, 15th November 2021 का circular था, which I'm sharing with you, which says that you don't need to, under section so and so and so and so, you don't need to have NOC from the Income Tax Department. Okay, you need to file some procedural reports with the IBBI also. What are these reports? This is preliminary report. Preliminary report has to be filed by the liquidator, whereby giving the details of assets, liability, and all annual status report. If your liquidation process goes beyond a year, then you are supposed to file your annual status reports also. Stakeholders being shareholders, you need to file their consultative report also. You have to file final report in Form H, which is the summary of whole liquidation process with the IBBI also. Petition format. Okay, I thought of sharing petition format with you also. So that you can have a gist of what actually how many pages it need to have. It's a very lengthy petition. 165 pages are included therein. You are supposed to file all the Form H, GNL2, all minutes of the meeting. You need to file all bank account statement, receipt and payment account, audited accounts, new due certificate from income tax. Now it is not applicable. Preliminary report and everything, whatever you have submitted to the IBBI or ROC, all this you need to file with in the final petition for liquidation of the company. Purpose of showing you petition format was that so that you can also understand how lengthy and big petition it is there. Yeah, these are what I told earlier, that what are the form prescribed under voluntary liquidation process. These are there. These are the particular forms prescribed therein, which you need to file before. In case of public announcement, form number A, if anybody has to file a proof of claim by OC, it is a form number B. By financial credit, it is C. By workman and employees, it is D. By ER of workman and employees, it is E. By other stakeholders, which is generally shareholders, it is form F. Okay, our office has prepared a flow chart so that in summary you can understand how much time it takes in doing this voluntary liquidation. And let me have a glass of water first, please. Yes, please. As I told earlier, board of directors to obtain declaration of solvency. Pass special resolution within 4 weeks of obtaining declaration of solvency. No, T mean that this is the time, the day you pass this the resolution, your 90 days period or 180 days period will start from there. And during that particular period, what you have to do, if there are any creditors, within 7 days, you have to get it approved. You have to make public announcement within 5 days. Intimate to the IBBI within 7 days. Notice to ROC and IBBI with reference to declaration of solvency, special resolution approval by creditors. It has to be with ROC 7 days and IBBI within 14 days. Submission of claims by stakeholders. Stakeholders go from the start of this thing, their approval of this passing of specification by the members. Within 30 days, they have to file the claim. They are given 14 days more time to modify or withdraw the claim, if any. Within 46 days of the start of the liquidation process, you have to submit the preliminary report. Liquidator has to verify within another 14 days all these claims. Whole process will take 60 days. 7 days के बीच में उसको इंटीमेट करना है कि उसने क्लेम एक्सेप्ट करे या रिजेक्ट करे. Then he has to finally prepare a list of stakeholders within 45 days or 75 days. 45 days in case of liquidation without creditors, 75 days if it is with creditors. क्रेडिटर्स ने एक पर्टिकुलर क्लेम का अमाउंट सेट करा, लिक्विडेटर ने एक क्लेम का अमाउंट सेट करा जो कि पसंद नहीं आया क्रेडिटर को. ही कैन फाइल एन अपील अगेंस्ट इट टू द नेशनल कंपनी लॉ ट्रिब्यूनल. Liquidator is duty bound to distribute proceeds within 30 days of realization. Deposit unclaimed amount in corporate voluntary liquidation account before filing dissolution application. What is this voluntary liquidation account? I'll let you know. Submission of final report to ROC, IBBI, and adjudicating authority in case of members voluntary winding within 90 days, or in case of creditors voluntary within 270 days. It's not 180 days, it's 270 days. Completion of all voluntary liquidation process within 90 days or 270 days. अब इसके अंदर एक क्वेश्चन आता है कि can we extend this period of 90 days or 270 days, or how we can extend? As far as extension of 90 days or 270 days are concerned, you don't need to require the permission of NCLT, which is generally a process in the case of other insolvency cases, even in the normal liquidation cases also. Here, you can take the approval for extension only from the stakeholders. This is what I've written, because when I'm speaking to you, you may miss something. These are the steps which I have written to you. Solvency, meaning thereby that in the first step, board should approve and voluntary liquidation, and must declare that the company is solvent, and voluntary liquidation is not done for defraud of any company. This is what I've told you earlier. You need to submit audited financial statement. Valuation of the assets as applicable, as I told you. I earlier told you also that to reduce timeline and to reduce the process of this thing, you can sell all the assets. Yeah, before making a payment, you have to deduct with the holding tax to this thing. For example, if you are making payment to shareholder, let's take an example that the capital of the company is 1 crore rupees, and you're the making payment to them of 10 crore rupees. Against 9 crore rupees, you have to deduct your tax at the rate of 10% under Section 194I and remit to them only 9,10,000. No, sorry, 9 crore 10 lakh only. The moment NCLT passes this order, your whole liquidation process ends. Yeah. Point number 3, pursuant to this application by the liquidator, the NCLT shall pass an order for dissolution and the entity shall stand dissolved from the date of NCLT's order. A clear copy of this order needs to be forwarded with the ROC within 14 days of the passing of the order. No. Let me tell you I've now prepared some slides on role of the adjudicating authority and what difficulties we face and what are the important landmark judgments in this case. The first is the role of the NCLT. NCLT is competent to declare the corporate debtor a person as a dissolved after due liquidation and distribution of its assets. The NCLT comes into picture only at the final stage of the liquidation after application for dissolution of the corporate debtor is made by the liquidator after distribution of the liquidation proceeds of the asset of the corporate debtor by following the procedures stipulated in the code. ठीक है, वॉलंटरी लिक्विडेशन के अंदर एक बहुत अच्छी बात है, इसके अंदर आपने सारे एसेट्स बेच दिए, सारा प्रोसेस कर दिया, उसके बाद आपको एनसीएलटी पे जाना है. Otherwise what happens is that under all the IBC proceedings, you need to go to the moment you put an application. जैसे IBC के अंदर आप section 7 की application file करते हो, section 9 की application file करते हो, या section 10 की application file करते हो. You need to go to the what you call to the NCLT immediately on filing of the application. Nothing like that is there. Here you have to go when you have completed all the process, and only for the dissolution you have to file to the NCLT. ओके यस यस वो जो एनसीएलटी जो है, जब प्रिंसिपल बेंच जो है वो क्या चीजें चेक करता है टू इवैल्यूएट योर एप्लीकेशन. They have given a checklist to all the insolvency professionals, which I think can be made applicable to, since it is the principal bench having overriding powers, having supervising power for all the NCLT benches also. You can prepare this checklist with you, and that will definitely help you in completion of your dissolution process at your list. I'm just sharing you that particular checklist. Just hold on. I'm just extracting that particular list. Yes, my screen is, I understand is fully visible. सेक्शन वाइज उन लोगों ने एक लिस्ट बनाई है जो कि मैंने भेजी है. जैसे फॉर एग्जांपल दे लुक इनटू डीपली इनटू इट that whether you are compliant these particular subsection or not. For example, section 59 subsection 3 subsection A, they look into it कि whether you are compliant, and जब आपने इसको कंप्लाई करा तो इसके रेफरेंस में आपको ये जो पिटीशन में पेज जो आपने ऑलरेडी पिटीशन फाइल करी है उसका सिंपली आपको रेफरेंस देना होता है. ऑडिटेड फाइनल बैलेंस शीट आपने सबमिट करी नहीं करी, वैल्यूएशन रिपोर्ट फाइल करी नहीं करी, स्पेशलाइजेशन फाइल करा नहीं करा, प्रूफ ऑफ रेजोल्यूशन 2/3 से है या नहीं है, एंड प्रूफ ऑफ पब्लिक अनाउंसमेंट एंड लिस्ट ऑफ स्टेक होल्डर्स क्लेम this is the checklist given by the principal bank, which you can need, or realization के ऊपर उन्होंने ये points check करने के लिए रखे हुए हैं. तो this is all you need to put it before the principal bench, and maybe with the other banks also, which can really help you in expediting all the process. And this can also give you the guideline also कि आपसे क्या क्या मांगा जाएगा at the time of this thing, at the time of filing your dissolution application with the NCLT. I'm returning back to my PowerPoint presentation. Yes. Yeah, you need to maintain, as per regulation 41, some registers also for preservation of record. These are specified therein. I just tell you that instead of these registers, you're not supposed to maintain any other record. Regulation 41, which prescribes records to be maintained by the liquidator. And I tell you that these records, the period for which these records need to be maintained. In electronic form, these need to be maintained for a minimum period of 8 years, and in physical form, these need to be maintained for a period of 3 years, so that if any of the authority asks you for any record, you'll be able to produce to them from the date of dissolution. Yeah, this is a briefly of what are the role of liquidator. These are the normal things which I have already spoken to you. Now let me move to some important things, because time जो है 1 घंटा 15 मिनट हो गया. Okay, one important process is there that let's understand this unclaimed proceeds of the liquidation with an example. Say, for example, that you have some NRI shareholder and you want to give them proceeds, and you are not able to, despite your best efforts, you are not able to get from them some details of some bank account, their bank account, or you are not able to trace to them. And it happens with big companies. In that case, you need to deposit these proceeds under Section 59, subsection 8. Firstly, you have to apply to the adjudicating authority for an order to pay it into the company liquidation account of the public account of India any unclaimed proceeds of liquidation or undistributed asset to any other balance payable to the stakeholders in his hands on the date of dissolution. तो IBBI के पास ये particular account है, तो they do maintain in it and do this thing here. Under no circumstances, liquidator can retain any money with them. Any liquidator who retains any money which should have been paid by him to the company's liquidation account under regulation shall pay interest on the amount retained at the rate of 12% per annum and also pay such penalty as may be prescribed by the board. तो आपके पास जो भी left over seats है, that you need to pay to the IBBI in a designated account and do it there. The person who later on comes across that he is entitled for this money, he can claim that money from that particular liquidation account. और उस account के अंदर वो पैसा 15 साल तक पड़ा रहेगा. और अगर वो even if जो entitled person है, he doesn't take it for 15 years, then it will be transferred to the it will transfer to the central government. Despite I'm telling you that the process is taking 90 days or something like that, but practically when we put an application with the NCLT, they take a lot of time, sometimes a year, maybe a 2 year also. But this the delay on the part of NCLT is not only for voluntary liquidation, it is for everybody. There's another issue which comes out in the voluntary liquidation process is that although for income tax circular has come out to be there that you don't need to have NOC. But if you want to take NOC from, say, from GST department, if you want to take NOC from custom department or PF authorities and several similar type of regulators, there is no format prescribed. There is nothing mentioned in their respective act. And when you go for getting NOC from them, it's a Herculean task, despite the having nil amount payable to them. So it need to be, this is an issue in voluntary liquidation, delay obtaining NOC, opening bank account. This is what I've told you. And, another thing is that if you listen to diligently, then there are conflicting provisions. One conflicting provision is that under section 178, subsection 2, assessing officer can ask the liquidator to make arrangement for payment within 3 months. But on the other hand, this liquidation process says that it will end within 90 days. How both their timeline are clashing, and how which will prevail or which will exceed. In that case, we have IBC provision which says in a particular section that if in case of conflict with income tax authorities or other specified authorities, IBC will prevail, meaning thereby that if you file the dissolution application before 90 days, of the statutory period available with the assessing officer, then it is not harmful. Under section 238 of the code, which clearly says this thing. And the section 178 subsection 6 of the Income Tax Act also has granted some relief now. I've already discussed in detail with you that how you can avoid tax under section 46 subsection 1. Opening a bank account, I've already shared with you that it is an Huygens task for liquidation account, but it's a subjective matter. You can open it up later on also. I prepared two slides for question and answers, which we come across practically to understand the whole process of liquidation. My first question is that sale of business versus sale of company. If your company is a going concern, you want to sell it. You can't sell it, but you can sell its business. There's a thin line of difference between business and the sale of a company. For sale of company, you have to voluntarily liquidate. In case of contingent assets, contingent liabilities, and uncrystallized liabilities, you can transfer it to the stakeholders, whereby they can, who should have been entitled for those assets, you can transfer to them. Signing of financial statements, it creates a lot of problem. Who will sign? Liquidator will sign, or director will sign? As I've written there, primary responsibilities of the directors, and liquidator is signing secondary. Can you appoint new directors during the liquidation process? Yes, you can appoint. Another point is that shareholders is also required to submit their claims, which earlier only creditors were supposed to submit there. If liquidator finds fraud, then make an application to suspend the whole process of liquidation to the NCLT. Outstanding creditors are prerequisite to discharge debts to their satisfaction. If there is any outstanding creditors and you want to go for the liquidation, you want to file that dissolution application, in that case, with the satisfaction on that particular creditor, you can discharge that debt and go for the dissolution application. Voluntary liquidation suspended on many litigations, but I've come across a case of Central Inland Water Transport Corporation Limited versus so. This is an old case, with reference to voluntary liquidation, where it was suspended because a lot of cases are pending against this thing there. Concept of withdrawal versus suspension. What is the withdrawal? Withdrawal means that you realize after filing your voluntarily liquidation application that you want to withdraw, whether you can withdraw or not. Suspension means that you find something wrong in the voluntary liquidation process, that the applications filed initially or the approval given by the shareholder was fraudulent. In that case, liquidator can file an application with the NCLT and go for the suspension. Once process started, court is silent on withdrawal, but courts have allowed withdrawal in the following cases. Yes, I've noted on some case law which can help you that if you want to withdraw the liquidation process, This is Dhankari Investment Limited versus Official Liquidator of Allahabad High Court. Anil Kumar Dua and others versus Gulshan Kumar Gupta, Icon Real Tech. In these cases, on the basis of circumstances, this was allowed. VB Purohit versus Jamukeshwar and others. It's an old case of Karnataka High Court whereby it was allowed. Withdrawal was allowed. Consul Hosiery, it was again allowed. If some tax cases are pending in the appeal, that you can dissolve the company subject to completion of all the formalities. This was allowed in the case of Commissioner of Income Tax versus Express Newspaper Limited by Supreme Court. Yeah, sorry. In the case of Consul Hosiery, NCLT Delhi allowed the dissolution despite pending of some income tax cases. But in my opinion, I come across contrary to this thing, because the Supreme Court has held in the case of Commissioner of Income Tax versus Express Newspaper Limited that if the company on the date of passing of the order, maybe the appellant order, is not in existence, no order can be passed against that. Meaning thereby that if the company is already stuck off, which I have seen in my lot of merger and acquisition cases also, whereby A and B companies merge into and C company is coming out to be there. And before the merger order, if any order is passed, after the merger order, if any order is passed against the A, this has been struck down by the appellant authorities. Yeah, we have a voidance application also there. Voidance application mean that liquidator find any fraud therein. That is also notified, as I earlier told in my slide, under section 43, covered under section 4351. And any proceeds or any receipts against that particular against voidance taxation has to be given to the shareholders. And if any voidance application is there, then will NCLT allow you to go for this thing or not? It's a subjective matter. Some benches are allowing, some benches say that until unless you conclude this particular thing, you have to bear this thing. This is all for 1.5 hour presentation by me. I hope I've been able to make to understand my audience everything. And now I stop my screen share. And yes, please.
Yeah.
If any, because if any questions are there, if anything else is there, you can ask me.
Yeah, this is by Swachandra Hans. Please indicate the normal time frame provided under the Act for voluntary winding up.
ये सर मैंने पहले बता दिया था, 2-3 बार मैंने बताया. In case of only members winding up, it is 90 days. Under IBC, and it is 270 days अगर कोई creditor की approval के साथ हम winding up करते हैं. This is as per the amended provision. I think 2 साल पहले ये चीजें amend हुई थी. उससे पहले time ज्यादा था. At present, this is the time.
A strike of application to the ROC different from voluntary winding up process.
This I have already explained earlier also. मैं इसको दोबारा explain कर देता हूँ. Strike off के अंदर आप अपनी जो है capital को वापस नहीं कर सकते. It wipes off. But in the case of voluntary winding up, आप अपनी कैपिटल को स्टेक होल्डर्स को वापस कर सकते हैं. और 1956 के अंदर सेक्शन 560 था जो स्ट्राइक ऑफ को डील करता था. और प्रेजेंट एक्ट के अंदर जो 2013 एक्ट के अंदर जो स्ट्राइक ऑफ का प्रोविजन है, दैट इज सो कम्बरसम दैट हार्डली एनी एप्लीकेशन इज फाइल्ड अगेंस्ट दैट पर्टिकुलर सेक्शन जो मेंबर्स स्ट्राइक ऑफ है. और नाउ ओनली अल्टरनेटिव लेफ्ट विद अस इज दैट गो फॉर द वॉलंटरी लिक्विडेशन, क्योंकि सिंस voluntary liquidation provisions of Companies Act 2013 has been deleted and has been transferred to the IBC, we need to go for voluntary liquidation only.
Why should one prefer voluntary liquidation versus strike off option?
Yeah, ये मैंने इसका आंसर दे दिया ना अभी आपको.
Oh, sorry.
Chat box से मैं ही पढ़ लेता हूँ. विकास जी, if you permit me, allow me.
That's the last question.
Yeah. नहीं सर, एक क्वेश्चन और था कि एससी सुभाष जी का, आर द टाइमलाइंस adhere to at all levels including NCLT or ROC? Invariably it takes years together to see the final order for voluntary winding up. Even please explain. I fully endorse views of the सुभाष जी कि लिक्विडेटर का तो अगर एक दिन भी लेट हो जाता है ना, तो वहां पे वो IBBI उसकी पेनल्टीज लगानी शुरू कर देता है। तो NCLT जो है, दे आर टेकिंग टाइम, जनरली साल 1.5 साल वो लगा देते हैं डिसोल्यूशन का ऑर्डर पास करने पे, लेकिन उसका हमारे को कोई नुकसान नहीं है क्योंकि हम उससे पहले अपने सारे एसेट्स डिस्ट्रीब्यूट कर चुके होते हैं। सर, विच आर द कंपनीज एलिजिबल टू अप्लाई फॉर वॉलंटरी वाइंडिंग अप? ये मैंने काफी डिटेल में आपको बता दिया था। एंड बेसिकली जिसके अगेंस्ट कोई क्लेम ना हो, जिसके अगेंस्ट कोई डिफॉल्ट ना हो, वो वाली कंपनीज वॉलंटरी वाइंडिंग अप के लिए जा सकती हैं।
Thank you, Manoj ji. These are all questions.
Yeah,
Since we are tied up, I would like to make a request to you. Kindly inform the audience that which all further sessions we are taking upon in partnership.
citation, I could not understand.
Which sessions we are going to do jointly?
विकास जी, आप वो यानी कि बाइंड करना चाहते हैं, कोई बात
Sir,
नहीं,
two
विद द पैसेज ऑफ टाइम वी शैल डू टेक इट। सिंस आई एम
26 वाला टॉपिक का आप नाम दे सकते हैं।
अच्छा, 26 वाला, हाँ वो मैं बता रहा हूँ आपको। सिंस माई सेल्फ इज स्पेशलाइजिंग ओनली इंसॉल्वेंसी एंड बैंक्रप्सी कोड, तो मैं तो इसके ऊपर कोई भी टॉपिक कभी भी ले लूंगा आपके साथ। 26 के अंदर जो हमारा यानी कि आज हमारी डेट है 9, उसके नेक्स्ट से नेक्स्ट सैटरडे जो है, उसके लिए हमने एक टॉपिक रखा है। वो टॉपिक हमने रखा है क्या नाम इसका, फॉरेंसिक के ऊपर। वाई फॉरेंसिक के ऊपर हमने उस टॉपिक को रखा है कि बेसिकली व्हाट हैपन इज दैट कि आपके सिंस यू एडवोकेट्स नोज फार फार बेटर देन मी, आपके क्रिमिनल प्रोसीजर्स लॉज हैं वो सारे के सारे चेंज हो रहे हैं। पीछे जी आई थिंक जब हमारा पार्लियामेंट सेशन चल रहा था, तो हमारे अमित शाह जी ने बड़ा क्लियरली कहा था कि जो ये जितने भी ये एरा के जो इन द सेंस कि इंग्लिश एरा के जो क्रिमिनल लॉज हैं, क्रिमिनल प्रोसीजर कोड है, या और भी 3-4 कोड्स हैं, उन सबको हम नए फॉर्म के अंदर ला रहे हैं। और अब अगर आप फॉरेन के अंदर इन क्रिमिनल प्रोसीजर कोड्स को देखो, तो इसके अंदर कोर्ट की इन्वेस्टिगेशन कह लो, या इसकी इन्वेस्टिगेशन कर लो, पुलिस की इन्वेस्टिगेशन कर लो, ये सारी की सारी इज डिपेंडेंट ऑन द फॉरेंसिक। फॉरेंसिक मीन कि अगर फॉरेंसिक एक्सपर्ट ने ये कह दिया कि उसने ये क्राइम करा है, सीइंग द टोटलिटी ऑफ द होल सीन, या अगर सपोज कर लो कोई ट्रांसैक्शन का फ्रॉड हुआ है, फॉर एग्जांपल सम मनी हैज बीन डिवर्टेड फ्रॉम ए कंपनी टू इंडिविजुअल और समवन एल्स, अगर फॉरेंसिक ऑडिटर ने कह दिया कि ये फ्रॉड हुआ है, ये फंड्स डिवर्ट हुए हैं, तो उसकी रिपोर्ट को एक बड़ा सब्सटेंटिव बेस मान के कोर्ट विल गिव द ऑर्डर। तो सिंस और एट द सेम टाइम जो फॉरेंसिक ऑडिट्स को कंट्रोल करने के लिए इंस्टीट्यूट ऑफ चार्टर्ड अकाउंटेंट ऑफ इंडिया है, इन्होंने अभी जून के अंदर ही, आई थिंक अराउंड जून ही, इन्होंने जो फॉरेंसिक ऑडिट के स्टैंडर्ड्स हैं इनको मैंडेटरी करा है, हम सीएस के लिए आल्सो और बाकी पीपल्स के लिए भी आल्सो। तो इस करके इस नई चीज को समझना भी हमारे लिए बहुत ज्यादा जरूरी है, और जैसे ही ये क्रिमिनल नया प्रोसीजर कोड आ जाएगा, उस समय तो ये मैंडेटरी हो जाएगा इसको समझने के लिए। इस ओवरव्यू के ऊपर हम 26 को आने वाले टाइम के ऊपर डेलिब्रेट करेंगे, उसके लिए हमने स्पेशलिस्ट को बुलाया है। तो दैट स्पीकर along with me will definitely deliberate on it.
Thank you, Manoj ji. And friends, tomorrow, do stay connected with us. I'm just sharing the topic with you. It's on the latest judgment of the Honorable Supreme Court. That is succession rights of Hindu children from void or whatever marriages by none other by S.R. Suryanarayan Rao from Karnataka. Do stay connected with us tomorrow at 6 p.m. Thank you. Namaskar. और हमारी अभी ये जैसे कि बात छेड़ी मनोज जी के साथ, ये भी कई jointly sessions लिए जाएंगे so that knowledge could be disseminated in the right perspective and right manner. आज आपने देखा ही कितने इन्होंने सिंप्लीफाई कर दी चीजें, जो इतना कॉम्प्लेक्स प्रोसेस था, और इनकी वॉलंटरी डिसोल्यूशन तो हम कर ही रहे हैं, और इन्होंने वॉलंटरी किया कि एक ये टॉपिक जो बहुत अच्छा है, इस पर मैं वॉलंटरीली आपके साथ इस ग्रुप में बोलूंगा। सो हम इस चीज का आभार भी प्रकट करते हैं अपनी एसोसिएशन की तरफ से, व्यूअर्स की तरफ से। शुक्रिया मनोज जी, थैंक यू।
Thank you very much. Yeah, Saturday evening hai. Everybody get together to listen to me and to have a webinar. Thanks a lot. आगे मिलते हैं. Thank you very much. Thanks a lot.